that it is also one should show non-conformity with the law when the law is bad, immoral, illegal. That's why amendments come in. That's why repeal of laws come in, and that's why we have various changes in law from time to time. But criminal law in India, the reforms which criminal law has is rather episodic. Now, why I term it as episodic? Because there has to happen certain event, only then there is some change in the criminal law. So that Mathura rape incident we all know, which had brought in major amendments, and without Nirbhaya we would not have such laws which we have today. By that sentence I don't celebrate Nirbhaya. I mean, because of that incident, few laws, accused-centric and victim-centric, have developed. So the question comes whether access to courts is access to justice. Because we may have access to courts, but we may not have access to justice. For example, the applications, the things which we file in the court from time to time, the time process which is there. I think you all know 4.13 crore cases are pending in India as per the National Judicial Data Grid website data. Out of that, 3.10 crore cases are of criminal which are pending. And COVID, as per my observation, has pushed the criminal justice system further 10 years back. Why I say that is that because the courts, the high courts were functional, not the lower courts. The video conferencing which they tried to highlight, I think if you have heard the Chief Justice of India a week back when he was speaking in India today, he also said that we need to welcome technology. So technology should be welcomed not only in the constitutional courts but also in the district courts. So from there I raise the question whether access to courts is access to justice. Now the concept of equal access to justice can be referred from the US Constitution in the 14th Amendment. So that's where the entire source of laws of US Constitution comes in. And there the case law, if you can refer, Griffin versus Illinois, what did the court do? The court changed an Illinois law which asks the indigent criminal defendant to pay a particular cost to prefer an appeal. So that indigent person, when required to pay a cost to prefer an appeal, that certainly did not mean access to justice, though the person had access to court. The next case law which we can observe is Smith versus Bennett, where the iron law asked the indigent prisoner to pay a fee for filing a appeal. That could be also noted over here. The court went ahead. Prison was also said to be a right which needs to be extended to them. Without that, they would said that they will not have access to justice, though may have access to courts. Now, when I talk of access to justice and fair trial, the very recently, I have not mentioned the year, Varindra Kumar versus State of Himachal Pradesh, the Supreme Court observes in 2019 that the principle of fair trial now informs and energizes many areas. So what could be the areas? It is a constant, ongoing, evolutionary process, continuously trying to adapt to the changing circumstances. And the court, while deciding the cases, needs to accept what are the changing circumstances, for example, the changing things which we have in the society. So non-conformity to the law must be in consonance with what the law is enacted by the legislature. And that is where the courts is under a responsibility to strike the right balance in their approach. Now, we always heard about there are some strike, there are some protests which are going on in courts. For example, the establishment of the circuit benches at North Bengal and which was already there in Port Blair helped the litigants. But what about a litigant who comes across or travels some 500, 300 kilometers and comes to know that the court is not sitting due to some incident. I am not criticizing the incident, but I am trying to take you through the law what the Supreme Court again has stated. So Supreme Court in Hussain and another versus Union of India says that one other on other respect pointed out that obstruction to court proceedings by uncalled strikes, abstaining of work by the lawyers is unconstitutional or cannot be accepted. In Harish Uppal, also the court suggested that there could be some friendly measures which can be brought in. For example, without having strikes on a regular basis, so every 2 months or a certain period of time, the condolences ceremony or things like that can be organized. This not only would enable the courts to function normally, but also to help the litigants who have come to courts for justice. Now, I said that the next part of the lecture will be to understand the position of the public prosecutor. So, according to me, the public prosecutor is sitting in the driver's seat of the criminal justice system. In whichever way he wants to drive, the justice system would be driven to. So by that sentence, I mean that the public prosecutor should not only be looking on for conviction, but also speaking on behalf of the victim of crime. So these case laws, Shivnandan Paswan versus State of Bihar, Ilango versus State with the Madras High Court, have all suggested that the public prosecutor cannot be the mouthspeaker of the police. The public prosecutor must not over enthusiastically be concerned only about conviction. Just let us think and observe for a second, if the public prosecutor thinks only for conviction, is it a fair trial? So he would only look for documents or things within the meaning of section 207 CRPC, the documents which needs to be given to the accused before the commencement of trial, which looks for conviction. But Supreme Court clearly said that consultation, I would mean there is hardly any opinion to evaluate, because previously in the 1898 code of CRPC, the public prosecutors came under the functioning of the Deputy Superintendent of Police, where the functioning or the evaluation could be done. And as we are not in a system of inquisitorial system of justice, but we are in a acquisitorial system of justice, there cannot be any discussion between the police officer and the public prosecutor before submission of charge sheet. So what we say that there could be influence. But is there no influence? I am not answering that question. I will leave it to the audience. So here in the Lakshman Rupchand, what again happened, that the complainant was raised against certain questions in the deficiency of the work of the public prosecutor. Public prosecutor behaved like a defense counsel. He was looking forward to save the accused person. That's not his job. Supreme Court has said that no, he has to put forward the facts of the case like an officer in court and nothing beyond it. Whether conviction, whether acquittal, it is the job of the court. That's where I always give the example that in India the trial system is like that cricket match where the prosecution has to bowl and the defense has to bat. Without that, the umpire cannot do anything. So similarly, that's how we can perceive the criminal justice. Now, confining or coming to the very core part of the topic, I already stated that it is the law enforcement network which is citizen driven. Citizen driven means criminal justice system, if we as citizens don't complain, the ball will not be set into motion. So the crimes which we see are registered may not be the actual number of crimes. There could be some crimes which have not been registered, or because the citizens have not informed. So that's why I say it is citizen driven. Then the other stakeholders are the defendant, the prosecution, the adjudicative network, which is the court, the correctional service. Now, if I come to the court topic, which is the accused. If you have heard about the UN Declaration of Basic Principles of Justice for Victims and Abuse of Power 1985, so that UN declaration categorizes four principles. One principle A is for victims of crime, where four principles, that is access to justice, fair treatment, restitution, compensation and assistance, should be given to victims of crime. And the B, the subpart B of that UN declaration talks about victims who are abused of power. Now, who are victims of abuse of power? The victims who are the accused, who are waiting for years for the trial to be completed. And they are also constitutionally provided that right. The right is envisaged somewhere between Article 20 to 23, that the right to be defended by a legal practitioner of your choice. So you all students should know that this profession, the legal profession, is the only profession which is mentioned in the Constitution of India. So we can call you that constitutionally ardent students. So coming to the exact role of the stakeholders. So I always say that without information, the crime cannot be lodged. So information, the time of the crime is very important for the investigating agency to know what is it. So the questions about the legal process can only be involved or can only be invoked when the stakeholder informs about the crime. So we all know that why we have this kind of laws for the protection of the accused. Someone here has heard about 2 years back during COVID in 2021, a person from Nepal was released from Damdam Correctional Home after 41 years, who was under trial. So situations like that don't happen. That's why we had amended the CRPC, and we all know section 41A, B, C, D and the entire chapter of investigation which is there. I am not going into that. I am trying to presently evaluate the present position of the accused and the victim of crime who is there before the court. So Rudolf Shah, you all know. So that's where the concept of compensation started from 1983. The person was there in the jail, and after 14 years it was found that after appeal he was still there. So the court said that the right to compensation is a palatable right, and that right cannot be ignored. Then Husainara Khatun also, that 40,000 persons were released from the state of Bihar, and that release was on the personal bond where they were released, and that is the time when Supreme Court interpreted that Article 21 would include right to speedy trial as well. So in spite of having these decisions, in spite of having the provisions in the CRPC, how come a person without trial stay in the correctional home for 41 years? That is where I relate the question with whether a person who has a right to court, whether the person also has a right to justice. Arnesh Kumar versus State of Bihar. If you have heard that offences which are punishable up to 7 years, the police has to mandatorily issue 41A notice. And some of the guidelines, if you want to know, that within 2 weeks the police has to decide from the institution of the case whether he wants to arrest or not. And that timeline can be extended by the superintendent of police. But how many occasions we do that? Or do we, in an ongoing investigation after months, years, we issue a 41A notice? So these kind of things are raises the question towards the point of access to justice. I think I have listed the points that also the accused who are to be forwarded, the magistrate should take into consideration the checklist which the police have also forwarded to him. So whether the magistrate grants cognizance mechanically or not, that is also a question. Justice Lokur, Madan Bhimrao Lokur, former judge of Supreme Court, before his retirement, he was of the opinion that magistrate should not grant cognizance mechanically. There should be application of judicial mind when the cognizance is actually granted. Because in India's justice system, you have to understand that there will always be cases which are filed. But the gates from where the cases should go out, that is restricted. So the time of taking or giving cognizance, it must not be with a view that okay, you take cognizance in trial, we'll see. So that's not the thing which is to be done, but which is presently is done. DK Basu, I am not going to repeat. You all know that establishment of control room, wearing of the uniform, having the nameplate, having the arrest memo, inspection memo, seizure list is all the gift of DK Basu versus State of West Bengal. Now, what is the history behind this? If you remember about Nilabati Behera versus State of Orissa, so that's where the history goes back. So Nilabati Behera was in 1993 and DK Basu was in 1996-7. So in Nilabati Behera, if I quickly tell you the facts in 2 minutes, that the son of the appellant, Nilabati, was picked up by the police, and after 2 days the body was found from the railway tracks. It was contended by the police that at the wee hours of the night he fled from the custody, and due to the approaching train it crushed. But the mother went and approached to the Supreme Court. A committee was appointed. It was seen that the injuries which was resulted was not from a train accident. It was also seen that the person was handcuffed. It was also seen that it could not be the way the person could have died as opined by the special committee. I think that time around 1 lakh or so was given as compensation to the appellant. So are we again, or do we again have reached the times of Nilabati or Sunil Batra versus Delhi administration? There was some brutal torture upon the accused person in the correctional home. Now let us come upon the impact upon the accused primarily. Now Nilabati Behera, Sunil Batra, DK Basu, all of these, Hussain Ara Khatun, Rudol Shah, gave us the law of 436A of CRPC. Correct? So the law of 436A basically is that when the accused person has already undergone half of the imprisonment for which he is accused of, except for the offences of death and life, the person can be enlarged on bail. Now if you see the figures over here, we generally refer them as under trial prisoners, UTPs. In COVID, Supreme Court released some 16 to 18,000 UTPs due to lack of space crunch in the jail. Now, what I have done over here, so the total prison population from 2015 to 19, I have shown that it is increasing. So from 2015 it was 4,19,000, it increased to 433, then to 4,50,000, then to 4,66,000, 472 and 478 subsequently. Now the glaring thing is that out of 4,50,000, for example, in 2017, 3,64,000 are under trials. So it is close to 70 to 71% of the total prison population in India are under trials. And you will be shocked to know that there are certain reports of CHRI and India Justice report which is prepared by Tata Trust, which have highlighted that there are under trials in some jails in Maharashtra close to 95-98% of the total prison population. And this is after we have all the laws which you have, I think you have already gone through investigation, gone through trial, and the case laws which I have taken you through now. And there are also foreigners who are also languishing in under trials as under trials. The numbers are less, but there is also a perception score about the justice system which we have right now in focused. So the foreigners also are languishing in jails, and there is absolutely no coordination between the District Legal Service Authority, the jurisdictional code, and the local police station, which is supposed to ensure that timely bail is granted. This is one glaring thing which I have tried to highlight. Now from here another question comes up, that we have said that we are dealing with accused and victims. The victims of crime is the person who has actually suffered a crime. So I am not going into that right now. So we are presently making the accused person the victim of the present system. The victim of the present abuse which the system is doing upon the accused. So as a result, the occupancy in the jails is also increasing with time. So a jail, for example, of 100 people now has close to 118 and 120 people. For example, in this auditorium, if we ask 500 people to come in, so we definitely cannot breathe, we will definitely collapse over here. So that is the condition of jails. And it is the criminal justice system which the state has created. So situation of under trials in West Bengal. So it is around 18 to 20,000 persons who are there in the under trials. There is a report known as Prison Statistics of India. So from that report I have tried to highlight this. And this is the thing which I was trying to mention, that out of jail after 41 years, 62-year-old Nepal man to head home with brother. Let us not be happy with the news that he is going back to home. Let us understand that in spite of the laws, in spite of the various rulings by Supreme Court which I have taken you through just now, the chapter of investigation and all, the person was in jail for 41 years. What could be the various stages over here? So the first stage which I was trying to tell was the stage of cognizance. There should have been certain measure why he would be in jail. After cognizance, before the trial starts, the stage of discharge. While the charge is going on, the trial is going on, there is a stage of framing of charge, alteration of charge. Along with that time, there is a provision in 321 which talks about withdrawal from prosecution. So what was the prosecutor doing in this case all this while when he was supposed to be, or while he was in the driver's seat of the criminal justice system of India? So these cases which keeps coming back is a hindrance in the present access to justice. So that's why I say there may be access to courts, but there may not be access to justice. Calcutta High Court gave 5 lakhs compensation, but again, that is not a sign of finding any happiness. That 5 lakhs is a substitute of 41 years. I leave the question to you. Definitely 5 lakhs cannot be justified as a time when the person has already undergone and 41 years. And this is one case. What about other cases which have still not come in the limelight? This is just one case. Because we do not have actual data that how many persons who have undergone the half of the imprisonment except for the offences of death and life as per section 436A is still inside jails. We don't have that data. It may be a data only with the respective correctional homes, but it is not made public. So as we do not have that data, it becomes very challenging. And that challenge is a constant thrive for speedy trial, which was recognized in Husainara in 1980. So have we reached back to Husainara? Have we reached back to Rudol Shah? Have we reached back to Nilavati Behera? Because that time, the amendments in CRPC were not there. So to students, I would like to advise that whenever you see one footnote after the provision, you check the bottom of the page. So which Criminal Law Amendment Act has brought a change, or in which year that amendment had come into place. So but with that, you try to relate the case law in which year it came into force. So I have discussed the present situation about the accused person in spite of having the laws. So whether this can be said as access to justice, I raise a question mark still. Now the second, the third part of the lecture, or the fourth part of the lecture, the last part we can say as conclusion, is about the victims of crime. Now, how many in the hall knows where NCRPC victim is defined from the students, please? Do you know where victim is defined in CRPC? Anyone? Because, why I am asking this question? Because we are constantly talking about the accused. The present criminal justice system we have made accused centric. We are extending the rights of the accused in the light of D.K. Basu, Agnesh Kumar, etc. Now again, I am not saying that you do not exercise the rights. But then again, there has to be a correct balance when we talk about fair trial. When Supreme Court interpreted that right to speedy trial in Husainara Khatun is part of Article 21, Supreme Court did not say that it is only for accused persons. So victim can be is seen to have been defined in section 2WA of CRPC. And surprisingly, there was no victim, or there was no definition of victim till 2008, because the definition was inserted by the 2008 Criminal Law Amendment Act. So from 73 to 2007 or 8, there is no victim, but the crimes are happening. It's funny, but that's where we finally define victim. So if you read section 2WA of CRPC, there is a word over there which talks about the accused has been charged. A victim of a crime would include a person against whom a physical, psychological harm has been committed, where the accused of the person, where the accused has been charged. It would also include the family members, the dependents, the legal heirs of the victim. Very well. Now, accused has been charged has to be, we can understand charge in two manners. The first concept of charge is alteration of charge, and the second is filing of charge sheet. Now, whether shall we wait till framing of charge, or till we wait till submission of charge sheet and then we recognize victim? No, because victim is also the informant, the complainant, which is before the police when the complaint is already filed. We have already traced the victim when we have completed the medical examination also. But still, then academically, it could be said that the definition of victim is somewhere still can be amended. Now, where victim is further defined. So, the UN Declaration in 1985 again defines victim. The UN Declaration, that is the basic principles for justice for victims and abuse of power, 1985. So, it is a very subjective definition which has been included, which not only recognizes physical and mental harm, but also recognizes emotional suffering, economic loss, substantial impairment of fundamental rights as violation. It also recognizes that states should identify such laws where this kind of definition can be incorporated. It includes immediate relief to the family members, not only to the victims. So the UN declaration should have been a better definition which can be found in CRPC, which could have been found in CRPC than the one which we have in section 2WA. That's where students can note. The UN declaration also gives us 4 principles: access to justice and fair treatment, restitution, compensation, and assistance. So these guidelines of the 4 principles which has been envisaged in the UN declaration must be implemented in the national laws of India. So where do we find, is the present criminal justice system is fair for the victims? Do they have any access to justice? Because here I would break for a minute and tell you an incident which happened in the Arya district in Bihar. So again, during the lockdown, there was a victim of rape who was in the court on the second day trying to record her statement. She was assisted by 2 members from the NGO, as she was not been assisted by the family member or someone close to her. And during the record of the statement, the accomplice of the accused person was there. Okay. So the victim requested the court that the statement to be read by the members of the NGO. Thereafter, the victim will sign the same. So the court declined. Victim felt unconscious. Court thought it is condemned. Court started a suo motu case under the Contempt of Court Act and sentenced the victim and the 2 other persons of the NGO to a court 100 kilometers from there without the test of COVID being done. The district and session judge in that Arya district of Bihar said, we will consider the bail of whom? The victim, whom you have made another category of victim in the same criminal justice process. So situations like that still happen in court. So by that, the learned session judge, I use the term, violated section 327 CRPC. What it says, court to be open, correct? We all can go and see the proceedings. But 327 CRPC makes an exception that court should not be open when cases under 376 or the offense of rape is being tried. So the learned session judge violated that because the accomplice of the accused person was there. So under this kind of situation, we definitely cannot answer or say yes to the first UN declaration principle, which says about access to justice and fair treatment to the victims of crime in the Indian legal system. Definitely no. Then restitution. If the courts, if the stakeholders, the police, the court, correctional homes, we as citizens are not aware that what is restitution. Restitution is what? Restitution is to do something to bring back the original state in which the victim of crime was there before the crime happened. Which are the laws? I will take you through some, but before that, whether the present criminal justice system is designed to restitute any victim of crime? I would say no. I would be happy to, if anyone contradicts me here. So that is one thing. Then compensation. So I have said that the first 2 guidelines are not there in the present national laws in India. Then comes compensation. Compensation we all know. 357 of CRPC has discussed about or the court's power to compensate. So in 357 subclause 3 it talks about that amount could be given to the victim of the crime or against whom the harm has been done at the stage of judgment by the court. But it had two problems. The first problem is the victim of the crime had to wait until the stage of judgment. The another problem is the economic condition of the accused may not permit the accused to pay the fine or pay the amount, which would again push the victim back for not receiving compensation. It could be another thing that the amount of compensation is not in parity with the statutory laws for which the victim has suffered the harm. So these were the problems with 357. So after that we thought that okay, let us make the state responsible. So in international law, Theo van Hoeven principle, it is known as Theo van Hoeven principle, where who would be responsible to restitute, to compensate, was the question which came up. So if these are the problems for the accused persons, so the responsibility has to be taken by the state. We are in a welfare state, not in a police raj state. So we follow the laws, we pay the taxes. That's why the state is under an obligation vicariously and responsible for the action of the stakeholders. That's why the Supreme Court asked in Nilavati's case to pay compensation, in Rudolf Shah's case to pay compensation, in Hussain Ara Khatun's case to release on personal bond, in Rajiv Gandhi's assassination case also, where the property were vandalized of Sikhs, though their lives were saved, the court again focused on paying compensation. So the vicarious liability concept started coming up. So Theo van Hoeven principle is from where this concept starts coming up. Now let us examine how the victim can be compensated. So victim emerges as a complainant or informant, correct? After that, victim becomes a charge-sheeted witness in the police record. Very well. The victim is given the copy of the FIR free of cost, the law says. But the victim is not given the copy of the charge sheet as defined. But only a notice of the charge sheet filed or not is sent to the victim. Yes, now you may say that some officers, they give the copy of the charge sheet. But that is out of personal relation or empathy towards the victim. But that is not a legal right for the victim. So here the victim is not aware whether the persons against whom the FIR is lodged is charge sheeted or not. Question 1. At the stage of cognizance, next, if cognizance is not given, correct, it could be also that victim is again not informed under section 191 that cognizance. So the court, there is no law which bars the court to call the victim of crime also, but the court is statutorily blind to not call the victim. So, but the victim has a right of compensation. Victim also has a right of appeal. Now a victim who has never been a part of the trial, can the victim know that there is right of compensation? Can the victim know that there is a right to file an appeal? I will discuss the respective provisions very soon. Then comes assistance. So if compensation is at that stage, I will carry on with compensation after 1 or 2 slides and show the actual implementation of compensation in India now. Because I can only see that from the UN Declaration Guidelines of 1985, compensation is the only principle which is extended to victims of crime. But how implemented, that we will soon evaluate. So I mentioned again the role of the public prosecutor over here. So victim has a right to engage an advocate. Do we know that? In terms of section 24 subclause 8 proviso, the right is there 24 subclause 8 proviso. But that right is restricted if you read section 301 subclause 2 of your CRPC. Why? So the private person who is engaged, he can only advance written notes of argument and assist the public prosecutor after the stage of evidence is closed. Public prosecutor will do what? Will tear that off and throw it away. Correct? Because in Rekha Murarka versus State of West Bengal, 2019 Supreme Court, Justice Abdul Nazir, he was of the opinion if we give the victim the right to oral participation, that would result in a vindictive battle between the prosecution and the defense. The quality of the prosecution will not match with the defense. But if we take into consideration the conviction rate for which the responsibility is on the prosecution, there our minds, our eyes will open. For example, in sexual offences, rape against women and children, as on 31/3/2021, 2,58,000 cases are pending. Conviction rate doesn't move beyond 24, 25, 26% as per the National Crime Records Bureau reports. So that was the argument of Supreme Court, that why the oral representation of the victim should not be given. Now, when we talk about victims of crime, from where it all started, whether courts have any view of that. We already spoke about the court's view for the accused. So it started with Delhi Domestic Working Women's Forum versus Union of India, 1995. So before DK Basu, we have a case for the victims of crime where certain guidelines were given by the court. One of the guidelines was that victims should also have legal representation. Similarly, like the guideline which we have in DK Basu, that the police station must have a list of advocates who is willing to appear in the cases, it was same to be reiterated in Delhi Domestic Working Women Forum. It also said to set up Criminal Injuries Board Compensation Board, CICB. We all know it has come up from Lakshmi, but no, it is wrong. It has come up from Delhi Domestic Working Women Forum case in 1995 to compensate victims of sexual assault and rape. It also said that it is the duty of the legal representative of the victim to make the victim aware about the court procedure and what are the duties the victim should do while the case is on. But what is much celebrated? DK Basu, because that's why I call the present trial accused-centric trial. But I do not mean to say that the rights of the accused should not be extended. On that question, I am absolutely no. Because UN regulation also say whatever rights to the victim to be extended must be in balance with the rights of the accused. You cannot encroach the jurisdiction of the accused. Because there was also a situation for the accused. If we again recollect Nilabati, Sunil Batra, Husanara Khatun, that's why the laws for the accused are like this. It may be we have still not reached like those stages for the victim of crime. That's why we still do not have the laws statutorily. So that was Delhi Domestic Working Women Forum. Then Suresh and another versus State of Haryana, again 2015 Supreme Court, it directs all states to legislate the victim compensation schemes as per the state of Kerala, because that was the state which provided the highest amount of compensation that time, Kerala. What the other states did, every state has a victim compensation scheme. Our state also has a victim compensation scheme if you search, 2017. So the definition of crime was not changing from state to state, correct? Compensable crimes, rape, acid attack, murder, all that. But the amount of compensation was changing from state to state. That's what states have very beneficially had legislated for themselves. So that's what Supreme Court dealt in 15. Ankush Shivaji Gaikwad is a very interesting decision again. Supreme Court says that courts are expected to assign proper reasons while refusing to award compensation to the victim. So what is the normal rule? Normal rule is to provide compensation. But courts still ignore this provision which was told by the Supreme Court in 13. So court should give reason why you are not giving compensation. Because 357A was legislated by the 2008 Amendment Act when the definition of victim of crime had also come. Hari Kishan versus State of Haryana and versus Sukhbir Singh from 1988. That time also Supreme Court says courts towards provision of section 357 is to award compensation to the victim when accused is released in admonition, probation, or when the parties enter into compromise. Because we cannot forget the trial may result in acquittal. That acquittal may be due to the lack of prosecution, the lack of evidence, the lack of evidence which was collected by the police, or something which the court could not go through. But that doesn't mean the victim of crime is not there. It could be a situation that the case has resulted in acquittal. Because criminal trial is again what? Whether Mr. A, who is the accused person, has committed the crime or not. The criminal justice system, as I have said, it is accusation-centric, is not designed to find out who committed, if not Mr. A. The justice system feels that the case has ended when the accused person has been acquitted. But maybe the real accused person is still roaming around. So that's what it says, that power to award compensation is not ancillary to other sentence but in addition to. In Hari Kishan in 1980, from 1980, Supreme Court is trying to say. I will relate to the latest decision till 2022. Dekha Murarka I have said in 19. So Jagjit Singh versus Ashish Mishra alias Monu. Supreme Court in April 2022. So it was the case, I'll give you the brief facts because that's how Supreme Court has finally changed his view. That it was a bail application which was being heard. And Criminal Law Amendment Act 2018 have incorporated a provision, section 439(1)(b). 439(1)(b) says that the notice not only should be given to the public prosecutor 15 days in advance but also to the informant. Informant is the complainant, the victim, as we can substitute the words. So the victim should be informed about the bail application which the accused has filed. It is not to not allow the bail application, it is to give a voice to the victim of crime in the present criminal justice system to ensure that if anything is not accounted by the public prosecutor and other stakeholders, the victim can tell the court and the court can decide the bail application. So it was an online hearing which was during the COVID times which was happening, and the connection lost when the informant's advocate was supposed to argue. The court decided the application and granted the bail. So that's where the appeal was preferred to Supreme Court and Supreme Court stated that no, there has to be, the informant should have been heard. The victim has a right of participation in every stage of the criminal trial, criminal proceedings, and the right of participation must be balanced with the rights of the accused. But I would like to say again, Supreme Court did not clarify how, where, till what extent the victim will participate. Because in 19, Rekha Murarka, which was a single judge bench decision, it limited, it rather took victim justice to step backward, where Jagjit Singh went ahead, but by going ahead, the court could have clarified till what extent and till what not. So, one more case, two more, if we can just highlight. Rathiram and others versus State of MP, again in Supreme Court in 2012, says that victimology, which fundamentally is the perception of a trial from the viewpoint of the criminal, that is the accused, which I am trying to say, as well as the victim. So it is not only accused, criminal justice is not only for accused, it is also for the victim. You need to recollect the crime happened on whom, who suffered the injury. So by the organization, as the prosecutions developed in the world across justice systems, victims slowly started to fade away from the justice system and remained a forgotten story. So the view of the victim is to be given due regard and respect in certain countries. It is the duty of the court to see that victim's right is protected. In Ratan Singh also, 1979, court accepts that it is the weakness of our jurisprudence that victims of crime and distress of the dependents of the victim, means the family member of the victim, do not attract the attention of the law, and it remains a vanishing point of our criminal law. So victim only remains a source of information and not beyond that. Now, if this is the situation for the victim of crime, there are certain impact upon the victim, which is known as victimization.